Well, it is a historic ruling with broad implications, and we wanted to get some perspective. So we reached out to Roger McEowen with the Washburn School of Law, and he joins us now this morning to provide that perspective. And as always, Roger, thanks for your time. So first of all, let's start with a bit of background on the history of the Chavez movement, if you would.
Well, Cesar Chavez was one of the co-founders of the United Farm Workers Association, and he was an organizer, an activist, particularly in California, but it did spread across other states. And a lot of states, and particularly California, did enact rules and regulations that purported to give unions and workers greater rights. But on the flip side of that, when you give one side greater rights, you run the risk of taking rights away from farming operations. And that's what the Supreme Court had to deal with this week.
So what specifically was SCOTUS asked to consider in this specific case?
Well, they were asked to deal with a California regulation where an ag employer was required to allow union organizers on their property for up to 3 hours a day, 120 days a year. And in the fall of 2015 at 5 a.m., members of the United Farm Workers entered onto the plaintiff's strawberry operation in Northern California without any prior notice. And as you said in the open, used a bullhorn to try to stir up protest by the workers. And some joined them, but some just couldn't work and they just left the facility. And this farming operation and some others down around Fresno, table grape operation, sued, saying, look, this regulation is basically taken a property right from us, and it's basically given you an easement to enter our property, our private property, without notice. And that was the issue before the court. Was that a taking or not?
So what might the implication now be for this nationwide?
Well, since the Supreme Court did rule 6-3 to uphold the property rights here and said this isn't a regulatory taking, this is an actual physical taking of a right to exclude others from your property. It really bolsters the point that an easement, a right to restrict other people from coming onto your property where you're getting nothing in return, there was no health benefit, there was nothing coming back from the state, that is a fundamental constitutional right. And that is the principle that can be applied nationwide. It's an upholding of property rights. And you can't just trot over those rights without running the risk, government, of having to pay for that right.
Now, is there any precedent that this could actually set beyond the farm?
Yeah, I think it's broad enough because they're talking about an easement in general. It's not restricted to agriculture, although it was applied to agriculture in this case because it was a strawberry operation in California that brought the case, and some table grape growers as I said, in the Fresno area. But the principle of the case that an easement is a fundamental property right, your right to exclude others from your property when you're getting no benefit in return, that is a broad concept that will apply well beyond agriculture's borders.
All right. Well, Roger, as always, thanks for sharing your insight with us today. We appreciate it. Roger McEowen, he's with the Washburn School of Law, connecting with us today. Of course, you can go online to washburnlaw.edu/WALTR for additional information. Thanks, Roger.